am Mwese Modupe Nye. In our previous episode on Introduction to Law and Legal Method, we did look at the meaning, the nature, and the function of law. On this episode, we are going to build on that by looking at the foundation or examining the various ways in which the law is classified. In so doing, we are actually looking today at the nature and the classification of the law. By the way, are you a member of this community? If you are not a member of this community, kindly be one by simply clicking on the subscribe button, and you immediately be subscribed as a member of this community. And this video adds any value to you, kindly don't keep it to yourself. Share it to others and give us a thumb up by way of clicking on the like button. And you want to communicate anything with us, kindly meet us in the comment section. Thank you. So the classification of law is not a mere academic exercise actually. It serves practical and analytical purposes in that it helps lawyers, helps judges, and also helps the students to understand how legal rules are organized, how courts exercise jurisdiction, as well as how legal problems are approached and resolved. So on this episode, we will be examining the major classifications of law, paying particular attention to their relevance within Nigerian legal system. So the first thing we are looking at is the meaning of the classification of law. When we say the classification of law, what do we mean by that? The classification of law actually refers to the systematic grouping of legal rules into categories based on their subject matter, their purpose, their scope, as well as the method of enforcement employed in relation to that classification. So classification generally will help you to classify the structure of the legal system. It will also help determine applicable courts and procedures. Classification of law will also distinguish rights and duties as well as remedies. And finally, classification helps in that it promotes coherent legal reasoning and education. So, as legal systems become more complex, classification becomes essential for order as well as understanding. So we will now look at the first type of classification we'll be looking at will be the classification of law into public and private law. So from that nomenclature alone, you will see that these are like words and opposite. Okay. So is either the particular law in issue falls under public law or it falls under private law. It should fall into one of these. So this classification is very fundamental. It's a fundamental classification of law in that it distinguishes both public as well as private law. And I'll begin by looking at what private law entails. So I'll begin by looking at what public law entails. Public law actually governs the relationship between the state as well as individuals. So as well as the organization and the powers of government. It is concerned with the exercise of public authority. So anytime you hear of public law, it deals with the public. It deals with the relationship between individuals as well as the state and organizations and all of that. So examples of public law are such courses as constitutional law, administrative law, criminal law. So constitutional law, of course, from the name, you will see that it regulates the structure of government as well as fundamental rights of persons. Then another example of a law that falls under public law is administrative law, and this controls administration of agencies and public officials. Then another example of a cause that falls under public law is criminal law. Yeah. And this addresses offenses against the state as well as offenses against the society. So generally in public law, the state is usually a party. The object is public interest, order and justice. And finally, remedies often include punishment or judicial review. So the opposite of public law, we already said, is private law. Now, private law governs relationship between private individuals or entities. Yeah. Now, the examples of such types of laws are contract law, tort, property law, family law. These are all private law. So in private law, you will see that the state acts mainly as an impartial arbiter. The objective of private law is to protect private rights, and the remedies are typically compensation or damages. So what is the significance of this distinction? The, the significance lies in that it affects jurisdiction of courts. It also affects the application of procedure, what procedure you are going to use. It affects the remedies that parties that are aggrieved will be seeking for. And finally, it affects the burden and standard of proof that will be required. Now, in spite of this, the boundary is never rigid. So some areas such as labor law and commercial law regulations may have both public and private law dimensions. Now, we'll go to another classification, which is substantive law and procedural law. And I'll begin by looking at what substantive law is. So substantive law defines the rights, the duties and obligation of individuals. Maybe you have heard it said that in Nigeria, for instance, the law faculties in the universities normally teach basically substantive law. So most of the subjects that they are teaching about what is this, what is that, what is this, what is that, and all of that. That most times falls within the purview of substantive law. So substantive law defines the rights, the duties, the obligations of individuals. And you see the examples are the right to freedom of expression, the duty not to commit a theft, the right to compensation of negligence, and all that. So substantive law will be teaching you what is theft, what is teaching, what is theft, what is stealing, what amounts to stealing, all those type of things. That's the kind of thing that substantive law teaches. Substantive law will normally answer such questions as what are the legal rights and obligations of a person. Okay, so the opposite of substantive law is, of course, procedural law. Procedural law is not concerned with the same questions that substantive law is concerned about. Okay, but procedural law is concerned about the procedure that you use to enforce the substantive rights that you have learned in substantive law. That's what procedural law concerns itself in with. So procedural law will concern itself, for instance, with the rules of court, the civil and criminal procedure, the law of evidence, things like that. So procedural law normally answers such questions as how are legal rights to be enforced, whereas substantive law is asking for what the rights themselves are. Procedural law is asking what's the procedure I'm going to take in order to get this right that I know is mine under substantive law. So to wrap that up, we'll be looking at the relationship between substantive and procedural law, and you find that substantive law is meaningless without procedural law. Actually, it's like a toothless bulldog without procedural law, and procedural Natural law is pointless without substantive law. Is like the teeth without the dog. So you see, so both must work together in order to ensure justice is done. So we'll look at another classification, which is civil or criminal law, and we'll be looking first at civil law. Now, civil law deals with dispute between individuals or organizations. Civil law is the opposite of criminal law. So when something is not a crime, then it falls in this purview of civil, isn't it? So civil law is actually the opposite of criminal law, and it deals with disputes between individuals as well as organization. The key features of civil law is that it's initiated by private persons. The remedies usually include things like damages, injunctions, as well as declarations. And finally, the standard of proof in civil matters or civil law is the balance of probability. An example of civil law is to be found in breach of contract, negligence, land disputes, etc. And then we'll now look at criminal law. Criminal law deals with offences against the state or against the society. And the key features of criminal law is that it's prosecuted by the state. The purpose is punishment and deterrence, to deter people from further committing such crimes against the state. And then the standard of proof, unlike in civil cases, is beyond reasonable doubt. The key examples of issues that you say are crimes are things like theft, murder, fraud, and so on. Now, what's the importance of this classification or distinction between civil law as well as criminal law? The distinction affects the parties to the case. It also affects the burden and the standard of proof that is required in the case. It affects the remedies as well as the sanctions that will be involved. It affects the rights of the accused person as well. Now we'll move to another classification, which is municipal law as well as international law. And you will see that in each case of classification is usually consistent as words and opposites. Municipal law is actually also the opposite of international law. If a law is not international, then it is what? It is municipal or domestic. So we'll first of all look at what municipal or domestic law entails. Now, municipal or domestic law is a law that is domestic or municipal, and it is not international. This refers to the internal law of a state. It relates to a state within that state and not outside. The law is made for a sovereign state and not made to operate between that state and another state. And so because it's made for that state, it's applicable within the territorial jurisdiction of the said state. So in Nigeria, for instance, when you are talking of municipal law, you'll be looking at the Constitution of the Federal Republic of Nigeria, for instance, as a municipal law. Then general legislation that are made by the requisite legislative houses, judicial decisions, customary and Islamic law. These are all municipal laws. Then on the other hand is the classification into international law. International law is opposite of municipal or domestic law. It's the law that operates between two or more sovereign nations. So international law will normally govern between states and international entities, and it includes such things as public international law, under which you'll be finding treaties and diplomatic relations. Then you also have private international law, and this relates to such an issue as conflict of laws. So in Nigeria, for instance, international treaties do not have force of law unless they have been domesticated by the National Assembly. Now, we'll now also look at the other classification known as written and, you guessed it right, unwritten law. So the opposite of, if something is not written, then if something is not written, then it is obviously unwritten. That's how you will be using and remembering all of this classification. Once you remember the one of them, you should be able to use English language to remember the corresponding classification. So we are looking at written and unwritten law here, and we'll begin by looking at written law. Written law, of course, is just what it is. It is a law that is what? Written. Simple. So a written law consists of all the law contained in formal written instruments. Now, example of some of these laws include things like the Constitution of the Federal Republic of Nigeria that I had called before, other statutes like say Violence Against Persons Prohibition Act. These are laws that are reduced into writing, and so they are written law. Unwritten law, on the other hand, are laws that are not reduced into writing, and so because they are not reduced into writing, they are what? They are unwritten law. So unwritten law consists of laws not contained in statutes. Examples of this will be like common law, equity, and customary law. So despite the name, unwritten law sometimes may be recorded in law reports and textbooks, but they are not codified. So that's it. So we have another classification into common law, equity, as well as statute. Now, common law consists of legal principles developed through judicial decision. It emphasizes precedents and case law reasoning. Common law is said to uh, common law is said to have proceeded from England, and it's said to be common because it was common. It was the principles and practices that were common amongst the shares in England. So, since it was common amongst the communities and the people in that terrain, they were just called common law because it was common to the people there. That's where it derived the word common law. Now, equity developed to mitigate the rigidity of common law, because common law, since it was reduced into principles, became very rigid, and the procedure to getting justice was very rigid, so much so that sometimes you would have won a case, but the outcome would not have occasioned justice for you because of the rigidity thereof. And so the court of chancery or equity was developed in order to mitigate the hardship of common law. That's what is called equity. So equity developed basically to mitigate the harshness or rigidity of common law. Now, the key features of equity are fairness and justice, as well as equitable remedies. And these equitable remedies are to be found in injunction as well as in specific performance. And then you also find equity expressed by virtue of maxims, known as the maxims of equity or equitable maxims. Now, the third one they were looking at is statute law. Now, statute law consists of laws that are made or enacted by a legislature. In Nigeria, for instance, statutes are the primary source of law. Now, they are, of course, subject to the constitution. They are not supposed to be at variance with the constitution. Where they become at variance with the constitution, they will become void. They will become null and void to the extent of their inconsistency with the provisions of the constitution. So we'll now look again at another classification, which is the ninth we are looking at, and that is customary law and Islamic law. Customary law and Islamic law. And the first we are looking at is customary law. Customary law is derived from the indigenous practices of the people, the indigenous practices and traditions of the people. Now, it is usually enforced only if it is not repugnant to natural justice, equity, as well as fair conscience or good conscience. Now, is all and you also check if it's not incompatible with any law in force as at that time. The other classification is Islamic law, which of course from the name you will see that is derived from the Islamic religion. So Islamic law requires primarily applies primarily in personal law matters in northern Nigeria through Sharia law courts. Now, so that's it. We also look at the importance of classification of law. What is the importance? We had made mention of it before, but by way of concluding, we'll now make a final note of it. The classification of law would normally enhance legal education as well as understanding thereof to assist us in determining jurisdiction. It guides lawyers in selecting appropriate remedies as well as promotes clarity and predictability. So, the classification of law reveals the structure and complexity of the legal system. While categories such as public and private or civil and criminal are conceptually useful, modern legal systems increasingly demonstrate overlaps in all these classifications that we have discussed about. So when you understand this classification, it equips you with the analytical skills that are required to navigate legal problems throughout your legal education as well as your professional careers. It's been a wonderful time being with you, and I hope that you were able to take away one or two things from this episode. I'm hoping that with this episode, you'll be able to explain the various classification of law. You'll be able to distinguish the major categories of law with even examples. You'll be able to apply the classification to legal problems, even in problem questions. Then you'll be able to understand how classifications affect courts, how classifications affect procedures, as well as how classifications will affect remedies that you are seeking in each particular case. Now, if you have enjoyed this episode, kindly like, kindly share, and kindly give us a thumb up. Now, in the comment, I would like to hear from you. To what extent is the distinction between civil and criminal law still relevant today? To what extent do you think that clear distinction between civil and criminal law is still relevant today? Let me see your comment or your response in the comment section. Till next time, I am